Welcome to part 2 of the 4-hour CE presentation addressing the business auto coverage form. If you have any questions or comments or that you need responses to, print them in the chat window in this program and or email them to our email address, and we will respond to you as quickly as possible. If for some reason you have difficulty, either auto or other, in this program today, please either again enter into the chat window or call 800-741-4084, 800-741-4084, and we'll attempt to correct the problems as soon as possible. In our previous 1-hour CE program addressing the business auto coverage form, we discussed the importance of making sure you list the correct name insured, the business that your assets that you're trying to protect. That will be the name insured on the business auto policy listed in item 1. It'll be any legal entity that meets that qualification on that line will later be considered a U in the coverage form. An individual, a corporation, a LLC, a partnership. Those are the legal entities of the business. There's also no need to name the owners, partners, and managers of these legal entities in item 1 of the declaration. Before today's out, we'll go over the why. You also must select the covered autos that will be considered covered autos in the form. This is by use of the symbols. To have the policy respond, the auto that was involved in the accident must make the definition of the covered auto, or the policy will not respond. You need to keep these considerations in mind as we move forward with the review of the business auto coverage form. If you're not familiar with this concept or are still confused about it, please review the first hour of the CE presentation that's provided to you on our website. In this session, we're going to talk about the auto liability coverage provided by the form and who the policy will protect. Remember, this form is designed and used to provide protection to businesses who use autos as a part of their business. The liability insurance agreement in section 2 of the policy is broken into 3 paragraphs. The first paragraph addresses bodily injury or property damage. Notice those words are in quotation marks, and we'll look at those definitions in a minute. And it will provide protection to the insured. Again, a quotation mark definition we'll look at in a minute. If they're legally liable for the bodily injury or property damage, if the insurance applies, which means it's not excluded, caused by an accident, and again, resulting from the ownership, means or use of a covered auto. Symbols are important. If the accident was not caused by a covered auto, then there's no coverage in the policy. The second paragraph has to do with specific pollution coverage, covered pollution cost or expense. We'll discuss this and that definition in a few minutes. Again, it's only going to respond when an insured is legally liable and if the accident is caused by a covered auto. The last paragraph of the 3 has to do with our rights and duty to defend. Key word there, duty to defend. The insurance carrier has to provide defense to the insured until the case is resolved, either by no coverage and successfully denying coverage, or by payment, exhausting the limits of the policy of a judgment or settlement. Other than that, they must defend the insured. So the paragraph, the insurance agreement for liability, tells us what coverage will be provided if the policy responds. Again, person or entity that is an insured in the policy must be the one involved in the accident, and an auto that meets the definition of a covered auto must be involved in the accident. Paragraph 1, direct damage, bodily injury and property damage. Paragraph 2, covered pollution cost and expense. And paragraph 3, our duty to defend, key consideration. So let's look at each one of these paragraphs, or at least the first 2. Direct damage. We'll pay all sums insured, again quotation marks, in the definition we'll look at in a minute. Legally must pay as damage because of bodily injury or property damage, again defined terms we'll look at in a minute, to which this insurance applies. it applies if it's not excluded. However, the insured must be legally liable caused by an accident and resulting from their ownership, maintenance, or use of a covered auto. Emphasis again on the symbols. So the vehicle involved in the accident must meet the definition of the vehicle, the symbols that represent what is a covered auto. So that's the insurance agreement 1, the direct damage. Policy will pay when insured legally must pay for bodily injury or property damage where insurance applies. And if a covered auto caused the accident, name insured and symbols must be done correctly or there's no coverage. In the definitions section, which is obviously section 5 in the policy, which I always found kind of ironical, in that we're reading now the words in section 2 of the policy, and we're reading words that have meaning later, but the ISO does not tell us what those words mean until we get to the end of the policy. However, what I try to do is bring those words forward, so as we look at their coverage being provided, we can also see what their meaning is. The first insured that we're going to look at is, the first word we're going to look at is the insured. That means any organization qualifies an insured in the who is an insured provision of the applicable coverage. That's any legal entity named on item 1 of the deck sheet. That's why that is important. However, we'll treat each one separately except for stacking of the limits. Suit means any civil procedure or accidents where there's damage or bodily injury, property damage, or covered costs of expense to which this insurance applies are alleged. And so it can include alternative resolutions like arbitration and mediation, as well as suits in the legal system. The other three more definitions that are important are bodily injury. That's hurting somebody's body, making them sick, or giving them a disease that might result even in death. That's the definition of bodily injury. Any kind of medical treatment, any kind of death caused by an auto accident. Property damage means damage to or loss of use of a property. This sometimes is not completely understood because we not only pay for the damage that's done. Our insurer runs into a building. We pay for that building. But if that building is a restaurant, we not only pay to have the building repaired, but we'll pay for the loss of the use of that restaurant, and meaning their lost income from that restaurant while the building is being repaired. In the commercial auto area, if our insured dumps property on the side of their highway, if our insured disposes their cargo, and that property of the damaged party cannot be used, even though there is no actual physical damage to a structure, we could still pay under the definition of property damage the lack of use of that property until it's properly cleaned and can be used again. Those are the consideration here, and it's a two-pronged that a lot of people don't understand, that we not only pay for the damage to the item, repairing, replacing the item that's damaged, real property, but also the insured's inability to use that real property or the property while we're making those restitutions or repairs. Accident includes continuous repeat exposures to the same condition, resulting again in bodily injury or property damage. In auto cases, this is very quick. In most cases, accidents, they're sudden, they're done. There's not a lot of repeated and continuous exposure except for the areas involved in pollution, and we'll look in more depth in the areas involved in pollution. The next key definition in the policy, and this is the key definition, particularly determining when the auto policy responds and or when the general liability policy responds, and that's the definition of auto. Under the current ISO policy, auto means a land motor vehicle, trailer or semi-trailer designed for travel on public highways, or, and this or was added in the 06 form, any other land vehicle that is subject to compulsory or financial responsibility laws or other motor vehicle insurance laws where it is licensed or principally garaged. So that's the definition of auto. Land motor vehicle designed to travel on public roads, or if it meets any requirement to meet compulsory financial responsibility laws or other motor vehicle laws, meaning it has to be licensed in the place it's registered. However, auto does not include mobile equipment, again a defined term. So the two things is autos would be accidents and motorized items that are autos, and those accidents that meet this definition, any damage done would be addressed by the business auto coverage form. Any damage done by mobile equipment, however, would be addressed by the GL form. That's the consideration for the forms working together. So if the unit involved in the accident is mobile equipment, then the GL policy responds. If the unit matches the definition auto, then auto policy responds. Again, designed for travel on public roads, licensed for the road, or has to meet compulsory financial responsibility in the jurisdiction that they're operating in, but does not meet the definition of mobile equipment. So we need to go back again to section 5 of the policy to look at the definition of mobile equipment. And I'm looking at this now talking about mobile equipment that might be a crossover, mobile equipment that businesses use that might be also considered auto in some form or fashion with those areas. So as we look down here, the first one that jumps out to me is farm equipment. There's a lot of farm equipment that looks like a truck that operates on the public highway that's used to move from field to field. It could be custom harvesting and combining in the midsection of the country. It could be dealing in specialty items like potato harvesting in Idaho and in Maine and the potato growing areas, or it could be things that are used in the citrus field, which I'm familiar with here in Florida, as also in Texas and California, that are called goats. These are motorized equipment. They aren't usually principally on the highway because they're used to harvest the wheat or harvest the potatoes or harvest the oranges and grapefruit. However, they might have to move from field to field, and when they move to field, they do travel on the public highways. And if they travel on public highways, in a lot of states, those items have to be licensed. So if you have an operation that's a custom harvester or a combine areas, or involved, or farmer agriculture risk that are involved in this, then there's a concern that you would have: is it mobile equipment? Does it have to be licensed or not? Second one is vehicles maintained for use solely on or next to premises you own or rent. This is prevalent in the trucking area, the motor carriers area, because we're talking about here the yard tractors. The tractors that are kept on the insured's premises to spot trailers for loading and unloading purposes or for maintenance purposes. You also could have some vehicles that are used in cemeteries or golf courses that are used only on those golf courses. They could be pickup trucks, they could be service vehicles with a small dump body. I've seen them in golf courses or in those areas. They're used on the insured's premises. So again, they would be mobile equipment in some definition if that's all they do, but if they get on the public roads for maintenance purposes, for going into town, for repairs, for fuel, then they might now because they're on public roads, be considered auto by definition. Crawler tracks, again, there are no question about those. Item 4, though, does list more vehicles that might be a crossover, and those are two specialty type risks. Power cranes, we have a lot of people involved in the businesses that have power cranes to unload or deliver trusses, to deliver equipment that in the motor carriers area we call them heavy haulers that deliver the items or unload or load the items on the truck. The second would be drill rigs, either water or oil. They primarily move from job site to job site. In the case of drill rigs, which is water rigs or oil wells, they stay there for a period of time. If they never leave the premises, if they're not licensed for the road, then they're mobile equipment. But very often, in most cases, the power cranes and the digger and the drill rigs will be licensed for the roads. Mobile equipment would be any kind of other road construction equipment. However, item 5 talks about not self-propelled. These are things that are towed behind a power unit: air compressor, pumps, generators, spray rigs, welding, lights, well service equipment. All those are mobile equipment, meaning that they'll be automatically covered based on the unit that is pulling it. And cherry pickers and similar used to raise or lower people. Again, not motorized. That's the key word here. Then item 6 says, I don't care if it's mobile equipment defined in the first 1, 2, 3, 4 paragraphs above, maintained primarily for purposes other than the transportation of persons or property. However, this is self-propelled vehicles that have the following type of permanently attached equipment. They are not mobile equipment, but be considered an auto. This is addition to license for the road. Equipment designed for snow removal, road maintenance, not construction, but road maintenance, street cleaning. B is a gray area. This is the cherry pickers. These are the people that use for power lights, to replace light bulbs, to replace overhead electrical wires, signs, those things. Or air compressor, pumps, generators, including spraying, welding, building cleaning, geological exploration, lighting, or self-service equipment. These items in 6 are carryover from the older form before we added this license for the road, because most of this stuff will be licensed for the road, so it would be considered auto in 2 areas. Not only the definition here that says it's auto, but because it also meets the requirement for it to be licensed for the road. But these are definitely not, again, mobile equipment. They would be considered auto. The catch-all here in the definition 5 in the policy, and by the way, this definition mirrors the GL definition. So everything we're saying here that's mobile equipment will have this, and auto will have the same definition in the GL. It adds here, I don't care if it's listed above as mobile equipment. If it's subject to compulsory financial responsibility laws or other motor vehicle laws, then in the place that is garage, then the land motor vehicles subject to those things are not mobile equipment, but will be considered auto. So that's the key part here. So how do we look at this? How do we look at it? How do we underwrite it? How do we do as agent? We've got to review the insured's mobile equipment, particularly if they're heavy haul, if they're involved in agriculture, involved in any kind of drilling operation, if heavy hauler, or have large premises where they have vehicles running around those premises. If licensed or should be licensed for the road, then their auto liability as well as the physical damage is addressed on the auto coverage form. We'll talk about physical damage in the next session in the 3rd hour. Concern if not licensed or should be. You'll have a lot of areas where you might have the units that are used on golf courses, units that are used on cemeteries, the units that are used on insured premises to spot trailers and all. They're not licensed. The licenses are not being enforced. The insured does not want to pay for the license because they're not on the road often. However, if they get on the road for service, for maintenance, to just happen to carry something down to the road for delivery, now they are subject to the compulsory financial responsibility and licensing law, yet they're not licensed. They still qualify as an auto. So it's not if it is licensed, but should it be licensed. There's also difference in state, particularly in farm equipment, where some farm equipment does not have to be licensed in some states, or if so, there's special licenses that do not require financial responsibility requirements. So depending on how mobile or how many states your insured operates in, it could also differ. The key here is you need to make sure that the general liability policy and the auto policy matches up. So if it's auto, it's covered on general liability. If it's mobile equipment, it's covered under the, if it's auto, it's covered on auto form. If it's mobile equipment, it's covered under the general liability form. The key consideration is the auto form symbols. If you use any auto, then there's going to be covered, whether we misinterpret the definition of auto or not. It will be covered under the auto form if it's later determined to be an auto. If it's not auto and you write it and you have a GL policy, hopefully with the same insurance carrier, then it would be covered under GL. So if you use any auto symbol and you write the policy with the same GL carrier as you do the auto carrier, and a loss happens, then there's no question of coverage. The only two questions that are open is what's the premium for that vehicle, and second is what loss line the insurance carrier is going to charge against. Again, there could be difference in that because, as most of you know, the auto policy does not have an aggregate where the GL policy does. But that would be the only two considerations. However, if you use the more limiting coverage symbol 7, specified only, in the policy that requires a vehicle to be a covered auto to be specified in the policy, then if you don't list that mobile equipment, it would not be specified. You could use a symbol 19 that we've talked about briefly that would cover any owned mobile equipment that's licensed for the road because of the financial responsibility, but I have not seen any insurance carriers using that. So as a retail agent, as an insurance underwriter, we need to walk through and see have we properly defined what's mobile equipment or not, particularly when our insureds are in agriculture, have large premises, in drilling operations, or in construction, because there's some gray areas to make sure that we properly have them defined. We probably have them covered either with any auto, hopefully, if not specified autos, specify them, and CGL with the same carrier. So need to spend time to go over those items with your insureds to make sure they're properly handled. The second paragraph that we have is pollution cleanup. It says we also pay all sums, again, an insured, meet the definition in a minute, legally must pay as covered pollution costs and expense. So in the first paragraph, we have a vehicle that has a crash, and let's say it's hauling fertilizer. That fertilizer escapes. That fertilizer gets on people's body, then that causes direct damage, bodily injury. The fertilizer gets and kills the grass, or a cow eats it, or kills fish in the water. That is property damage. But now that we have the pollutant, which we're now calling fertilizer, on the premises, soaking into the ground, in the waterways, it now has to be cleaned up. So this second paragraph talks about covered pollution costs and expense. The first one was direct damage. Again, it's only when the insurer is liable and only when the necessitating covered pollution costs and expense is caused by an accident by a covered auto. So pollution damage coverage as relate to bodily injury and property damage. Pollution damage coverage found in the first insurance agreement but not excluded. Direct damage and loss of use. That's killing, hurting people's bodies, killing people by the escape of the pollutant, and or damaging trees, water, fishes, animals. That's all property damage. But now that it has damaged, the items need to be cleaned up and taken out of the environment, and that's covered in the second paragraph, and that's the covered cost, pollution cost or expense. Again, notice that the covered pollution cost and expense is a defined term. So we'll look in the policy in a minute about the defined term. Let's step back for a minute and look at an auto accident and look at where the pollutants could come from out of a typical auto accident. There are three places. The insurer could be carrying those items. It could be inside their cab. It could be in the pickup bed. It could be in the step van in the back. It could be in the box truck. It's a straight truck, or it could be a small service trailer where you have a lawnmower that falls off, and or tractor trailers in the big. The items carried in those items could escape and could do damage, whether it's gasoline, diesel fuel, fertilizer, or anything else that could damage the environment that could escape. So for the first place the pollutant could escape from is from the property and the insured's care control that they are carrying. The second place the pollution could come from in an accident will be from the fluids that make the vehicle go. Gasoline, diesel fuel, depends on how it's powered, contained in the reservoir that's designed to be carried in, meaning the diesel tanks or fuel tanks. It could be the hydraulic fluid if it's a hydraulic system with lift apparatuses. It could be even simple as the batteries and the battery acid. It could be for the hydraulic, for the brake fluid, or for the power steering fluid. those things turn over, and if the vehicle has a crash, those things could escape doing bodily injury, property damage, and possibly need cleanup. The third place that our insured could cause a pollution incident is if they run into someone else's property or cause someone else's property to escape. That's third-party property, not in their care, control, that they do not own, that they cause to escape. Example that I use, and unfortunately happened in one program we had, where we had an insured that ran into a field in an orange grove and came close to a maintenance facility, and there was a hose sticking across the road that our insured ran over, causing the hose to come loose from the spigot. The spigot was tied to 1,000 gallons of a herbicide, causing it to escape. And we had to pay under our policy for the cleanup for that, because that's the third-party property our insured caused to escape. It could be a tank like that, or it could be another vehicle our insured runs into. So looking at an accident, there are three places that a pollutant could possibly come from. The things the insured are carrying in their vehicle: cab, pickup bed, box van, tractor trailer, fall-off. The second one is the fluids that make the vehicle go, and the third one is somebody else's property our insured negligently causes to escape. So what's a pollutant? Again, back to Section 5. It's anything that's yucky. It's anything that can cause damage to the environment. Liquid, gases, thermal, heat, meaning contaminant, including smoke, vapor, smoke, fumes, acid, alkaline, chemicals, waste. Waste includes material to be recycled, reconditioned, or reclaimed. Anything that can change the environment. Anything that's yucky. The second definition of Section 5 is covered pollution, cost, and expense. Again, a defined term. What that means is any request, demand, or order, or statutory or regulatory requirement that any insured or others test for, monitor, clean up, remove, contain, test, detoxify, or neutralize, or in any way respond to or access the effect of a pollutant defined earlier, or even any claim or suit by on behalf of the governmental authority, the EPA, for damage because of testing, monitoring, cleanup. That is what covered pollution, cost, expense is. Not only the actual extraction of the items from the ground, but also monitoring, testing for detoxification, making the environment back in the position it was before the pollutant event happened, either because the property owner is requiring it or the government authority is mandating the cleanup. But there's not covered in a couple areas. First off, it's not covered if pollution, cost, and expense does not include any cost or expense arising out of actual, alleged, or threatened discharge, expel, seepage, migration, release, or escape of pollutant. That is an insured's care, custody, and control. That they're loading or unloading, that they're transporting, that are being stored or disposed in the vehicle. In other words, if it comes out of the vehicle before it is loaded onto the vehicle or after it is taken off of the vehicle to the final resting place, that's not going to be covered under covered pollution, cost, expense. So anything in the insured's care, custody, control, what we say here is that it's their cargo, the things they're hauling. If that caused a pollution incident, then there's no coverage under covered pollution, cost, and expense. However, we do have coverage under covered pollution, cost, and expense if it's the fluids that make the vehicle go. Again, diesel fuel, gasoline, hydraulic fluid, those items. So contained in the reservoir, they're designed to be contained in. So if the fluids that make the vehicle go cause the pollution, then there is coverage for covered pollution, cost, and expense. There's also coverage in the pollution damage caused by third-party property. Somebody else's property I insured caused to escape. There's coverage for that. So in summation is for the cleanup, covered pollution, cost, and expense. If the cargo, anything insured's care, custody, and control, being carried in the cab, in the bed of the pickup truck, in the back of the step van, in the straight truck bodies, in the service trailers, in the semi-trailers, if those items escaped and there's pollutants in those items, fluid, acid, fertilizer, batteries, diesel fuel carried in the back for services, then paint, hydraulic fluid, oil, then there is no coverage for those if those escaped and caused pollution damage. However, in this accident, if the fluids that make the vehicle go, the gasoline, diesel fuel caused the accident, yes, there's coverage, as well as battery acid, hydraulic fluid. Or if our insured hits some else's vehicle and or runs into a tank or over a hose, in the example I gave you, causing the other person's property that's not in the insured's care, custody, control to escape, then there's coverage for that. As we're looking at pollution, let's also look at the direct damage. Remember, paragraph 1 covers bodily injury and property damage. So then we look at the exclusions in the policy, and exclusion 11 addresses the pollution. Exclusion 11 says we exclude the bodily injury or property damage arising out of the actual, alleged, or threatened discharge, dispel, secrets, migration, release, or escape of pollutant. Again, that is an insured's care, custody, and control. It's their cargo, being loaded or unloaded or transported or storage on the vehicle, and from the place it's first talked to the insured until it is made its final delivery. So therefore, again, if cargo escaped and that cargo caused pollution damage, we not only pay in the previous definition of covered pollution cost expense for the cleanup, we also don't pay the bodily injury or property damage. But we do address in the coverage form, because paragraph A does not apply if it's from fluids for the service of the unit. Diesel fuel, gasoline, hydraulic fluid, hydraulic fluid, battery acid, power steering fluid, those items, or if our insured causes other people's property to escape, then there's coverage in the form. So again, the coverage does not cover any pollution losses, both bodily injury and property damage, and cleanup if it's caused by the insured's cargo, anything in their care, custody, control. There is coverage under unendorsed ISO forms if it is caused by the fluids that make the vehicle go, or is caused by insured's causing third-party property to escape. So direct damage, bodily injury, property damage, no coverage for cargo, yes, coverage for fluids that make this vehicle go to service the vehicle or other people's property. So current ISO forms provide no coverage for pollution losses caused by property being transported by an insured except for the fluids that make the autos go. Where do you think most of the pollution is going to be? In your insured cargo. This is what's going to do the major damage. If an accident occurs and the cargo is spilled and does pollution damage, the insured will have to pay for the direct damage via IP up and cleanup because there's no coverage. However, if they buy insurance, and we can do this by endorsement, then the insurer will have to pay. This is why the insured buys coverage. So in this discussion is the best for the insured is to provide coverage. And anything that's best for the insured is also best for the retail agent. That coverage is by a endorsement to the policy, standard ISO, endorsement CA 9948, pollution coverage to the auto form. Some carriers include this with a quotation. Some carriers will provide it with a premium charge. And there's a couple carriers where the form has it already built into it. So the question or the situation that we're having here is, as a provider of commercial auto business, in my opinion, you should always ask for the pollution buyback coverage, C9948. The ironical part about this is risks that are involved in hazmat hauling. Their carriers typically add this with no coverage cost. Some of the other carriers will not do this, and then that's where your discussion is. It is available in the marketplace. It's something that you need to look at, even if you have to have more than one quotation. If you have a quotation where one carrier has pollution coverage with a CA 9948 or similar endorsement that's provided within the premium, you need to point that out. You need to also point out if you can add some more premium by endorsement, or if you cannot provide it. When you cannot provide it, you need to let the insured know it might be available, but you just do not have a carrier who's willing to do it. So this is a key consideration to request for it. However, there are three states that you don't have to worry about. If your vehicle is domiciled in one of these three states and the policy that is being issued is issued under the Department of Insurance regulations in those states, New York, Vermont, and Virginia, they have a mandatory endorsement that removes the pollution exclusion. So in these states, you have full coverage policy limits for any pollution damage done, including pollution damage caused by the insured cargo escaping. You have other states, New Jersey, Massachusetts, Kentucky, and Kansas, that does not allow pollution exclusion to the minimum state financial responsibility limits. Massachusetts, I think, is 60,000. New Jersey, I think, is 15,000, 20. Don't quote me on these limits. Every state can be different in this. In this cases, you have full defense coverage. You just do not have a limit available like you do in New York, Vermont, and Virginia. And so in these states, New Jersey, Massachusetts, Kentucky, Kansas, even though it's a state mandatory endorsement that provides pollution coverage at the state limit, I still recommend having the CA 9948 or slimmer endorsement added to the policy to get the full limit coverage. Again, you don't need to do that in New York, Vermont, or Virginia. You need to see what's required for pollution coverage in your state, and you need to provide it whenever possible. So you need to ask every carrier you do business with, running commercial motor carriers, commercial auto risk, how they approach pollution coverage. You must offer the coverage, even at a higher cost. You need to offer both. This particularly is important for retail agents from multi-markets or wholesalers from multi-markets where you quote both. It is available. It's only a question of cost, and that question should be the insurance option, not us, not ours. The CA 9948 endorsement, this is the 1213 version that you would look at. This spells out the coverage that is provided for bodily injury, property damage, and covered pollution cost of expense, even for cargo. There are some government requirements I want to briefly talk about here. One of them has to do with pollution here. If the insured who have business that uses commercial autos might have to meet government-imposed requirements, both registration and financial responsibility. The considerations are this. Are they interstate or intrastate operation, meaning do they cross state lines or not? Size of the vehicle. Larger the vehicle, there's more requirements. And are they hauling things they own, they don't own, or hauling hazardous material? If the vehicle the insured is using in business never crosses state lines, then they must meet state requirements. Some states increase financial responsibility based on the size, like Florida. Some states, 30 or more, require a registration at the federal level, state level, and a DOT number attached to it, even though they are not interstate commerce. However, if the vehicle crosses state lines for commercial purposes and the unit is 10,000 GVW or larger, meaning they have 6 wheels or more, then they must obtain a federal DOT number. This is being enforced aggressively now. I've had a number of instances here where the businesses that are not true trucking, true motor carriers, cabinet shops and well servicing rigs and contractors hauling trusses and welding operations now, because the units they have are dualies, 6 tires, cross state lines, they're now having to have a DOT number. And if they have to have a DOT number, again, their information can be found in SAFER, a major consideration for underwriting business auto, not just true trucking, because the federal government considers a motor carrier and requires that motor carrier to be registered and obtain a DOT number if the vehicle has 10,000 GVW, 6 wheels or larger, and cross state lines for business purposes. The second part of this, and this is where we get this, there also could be financial responsibility. If the insured hauls property of others for hire, when property is interstate commerce in a vehicle 10,000 GVW or larger, then they must have endorsement of their policy. MCS 90 will limit at least $750. If hauling anything hazardous, both private and for hire, any quantities across state lines, then they must have this endorsement of the policy. If they haul intrastate only and they haul it in bulk, they must have this MCS 90 endorsement to the policy. The limits in the case of hazardous haulers, both private and for hire, $1 million or $5 million, depending on the hazard nature. The current enforcement of this requirement is at a DOT officer's inspections at the insured's location. However, this is going to change drastically, or the law has, the Uniform Carrier Registration System has been completed, and as of October 2015, these risks, both private and for hire, who meet this requirement, will have to have a filing, not only the endorsement of the policy, the MCS 90, but a filing sent to the Department of Transportation. We don't have time to go in detail on MCS 90 here, and some of you have been in my classes, or I encourage you to do my classes in more depth. But it's an endorsement of the policy. There's a cancellation requirement in writing that's bilateral for 36 days. It protects the public for any auto 10,000 GVW or larger that the insured uses, which incurs, and that includes environmental restoration, pollution cleanup, whether there's coverage in the policy or not, whether you don't have the right symbols or you don't have the pollution buyback, the public's still protected. But the insured gets no coverage because the form has a reimbursement provision in it. So when you look at the pollution element, if you attach the MCS 90 to the policy, you would have to pay, if you're an insurance carrier, for the pollution cleanup. The question then is there any coverage in the policy? Do you have the 9948 endorsement buyback? If you don't, and you pay a pollution loss, then you could subrogate back against the insured. It's not coverage. This is why, for anybody involved in this, you need to understand that you need to ask for this coverage whenever possible. That's the insurance agreement. That's the bodily injury, property damage, and covered pollution costs and expense. So let's see who the policy is going to provide. Who is insured? The policy wording says you are an insured. You or anyone listed on the deck sheet, but only for covered auto. This is why symbols are so important. Anyone else, while using with the insured on the deck sheet, permission of the covered auto that the insured owns, hires, or borrows. The permissive user can be three different types of operation. First off, clearly that could be the driver. Notice it doesn't use employee here. It uses, like you do in GL, it's any user of that vehicle with insurance permission. It could be an independent contractor, it could be a neighbor, it could be a family member, anybody using the vehicle with permission. If you're insured or have operations with trailers and they loan their trailers to someone, then that user of that trailer is a permissive user of that covered auto. So it's any permissive user of that covered auto. The policy responds if an entity that meets the definition of insured is involved in the accident, is caused by a covered auto. Insured is the you listed on item 1 of the deck. Any legal entity who meets the definition of who's insured provision, use the name of the deck sheet, and anyone else with permission of the you. However, there are 5 situations where the owners of the covered auto are not covered. Now here's the important part here. It's not the insured. It's not the permissive user. They have coverage. It's where the owners are not covered. The first one is the owner or anyone else from whom you hire or borrow a covered auto. This is clearly not applied to covered auto. That's a trailer connected to covered auto. So the trailers, not only trailers, owners are protected, but the owner of that vehicle is not. So if you borrow your neighbor's vehicle, if you use your neighbor's vehicle for usage, if you go borrow one and an auto accident happens, you're insured, the driver's insured, but not the owner of the vehicle, not the neighbor. Second one is your employee, if the covered auto is owned by the employee. So if your employee picks up mail, if your employee is a sales rep and has an auto accident, you have proper coverage in your form, either any auto or non-auto coverage in your form, then the business has coverage, but not the owner of the vehicle. We also do not cover someone using covered auto while she's working for a garage. When you put or auto service business, when you give your dealership or you give your auto service business, they have permission to test drive your vehicle, but they're not a permissive user under this form. They must rely on their own policy. The second one is anyone other than your partners, members of your household limited or lease or borrow of any vehicle while moving property. The loading and unloading, again, your permissive users would be, but nobody else you hire to unload the loading. For us who are involved in the trucking business, that would be the lumpers. Even though the permissive use of the auto and loading and unloading has been considered the use of the auto, they're not covered. They'll be covered under their GL. The other person who's not covered is your partners for partners personally owned vehicles. They're not covered. So the key part here is 1, 2, and 5. The insured's covered, the permissive user's covered, but not the owners of these vehicles. When you go back to what we discussed in section 1, or the first hour in this, we talked about listing the vehicles in item 3. You want to make sure your insured owns those vehicles that we list that are covered autos. If they're not owned, then we might want to cover the owners of those vehicles. So the insured and permissive user will be protected, but not the owners. If the non-auto covered auto, unless an endorsement is added. Consideration, find out who owns the autos that is covered autos. Scheduled item 3. And if owned by other than the you need to add one of these endorsements we'll talk about in a minute. Do not list the owners on item 1 of the deck sheet, but add the endorsement to the policy if they own the vehicle personally and the corporation or partnership or LLC is insuring you. Beside the you, the permissive user, there is a third situation where someone could qualify as insured. The wording of the policy C says, anyone liable for the conduct of insured described above, but only to the extent of that liability. This is anyone that's being held vicariously liable for the insured. Folks, this is the insured's customers. This is anybody the insured works for. This is a blanket additional insured. It's built into the auto form. You do not have to add an endorsement. It's already in the form. So all your insured customers, anybody that the insured is requested to send a certificate of insurance on behalf of, naming them the additional insured in the commercial auto form, standard ISO commercial auto forms, both business auto and the motor carriers form, that entity, those customers are already insured without adding any endorsements. So making the customer of insured an additional insured. The insured wants to add others as additional insured on their policy because of doing business with them and this requirement of their customers. They cannot haul or get paid until the customer of the motor carriers get a certificate of insurance reflecting coverage, and they are additional insured on the policy of the motor carrier, the business auto firm, who they haul load for. Folks, they already are. If you have permission to, there's no need to add an endorsement. They already are insured because of vicarious wording in the policy. There's no additional coverage provided by any endorsement. So if you have permission to send certificate insurances out on behalf of your insurance carriers, you can put in the comments section, you, the customer of the insured, is additional insured per item 3, item C of the commercial auto provision C and the who's insured provision of the policy attached to it. That comments and those wordings are no different than saying what the limit is and what auto schedules you're using and if they're covered or not, because that's the wording in the policy that we have and the coverage that is provided by the form itself. So there's nothing we can add to give the customer any more protection for their use of covered auto and operated by our insured without picking up some of the customer's liability. All the protection needed is already there. There's no additional coverage can be provided to the customer of the owner of the owner of the auto. You just list it on the deck sheet. By virtue of provision C of the who's insured provision of the above policy, name the customer as additional insured. This is blanket additional insured. However, we have some insureds with customers that I consider have low self-images. They don't believe the policy. They have, quote, experts, risk management saying, well, you need to be added as additional insured on it. So ISO has promulgated an endorsement, the CA 2048 designated insured endorsement, where we can add it to the policy to make these people happy. This is the designated insured endorsement covered auto, CA 2048. But the prevailing word in this is oh, wait a minute, is in the bottom of this paragraph, what says, each person or organization shown in the schedule is an insured for covered auto liability coverage, but, keyword, but only to the extent that person or organization is an insured under the who's insured provision. So by adding this endorsement, the only thing that you do, the only thing that this accomplishes is if that customer of your insured do not believe they are anyone, we'll put in writing, we agree you are an anyone. It does nothing else. It gives them no additional status. It gives them no additional coverage in the form. The form already has the coverage in it. It's a designated insured endorsement 2048. There are some other endorsements out there that some carriers have promulgated, but none of them add any more coverage than what's already in the form. In other words, if the insured is held liable for the actions of our insured and named in the suit because of our insured's actions, they're covered. There's no endorsements going to pick up the customer's negligence, and it's already built into the form. So by adding 2048, you satisfy the insured's customer's requirement to see their name in it. The only thing you do is clear up the question, are they or anyone? Because anyone's already covered. So your insured has customers that want to be named on the name insured line item because of their ownership. This is another consideration, though, because owners are not covered, but they would own the vehicle. Why would the owner be named in the suit? These are the people who own the legal entities. Legal entities could be a corporation, LLC, or partnership. If you remember, I talked about it in the first hour. You'll hear that you do not add them on the name insured line. They're already covered. Here's why they're already covered. If I own the business, I'm not driving the vehicle, an accident happens, I'm named in the suit because of my ownership of the business, not the vehicle, of the business, then I'm covered. So this wording covers everybody who are the ownership, stockholders, members, or people who run the organization, managers, executive officers, directors of the business, when they're named in the suit because of their relationship to the business. They're already covered here because the complaint's going to be you're being held liable for the entity that you manage, the entity that you own. So this covers all owners of businesses without naming on the deck sheet. However, if they own the autos personally and it's insured by the business auto policy of the business they own, or if there are others who own the autos, that's a covered auto, mainly leasing companies or in the trucking industry, owner-operators. These owners of non-owned covered autos must be made and insured by endorsement to protect them from possible being held liable, legal liable because of their ownership of the non-owned covered auto used by the insured. So the person who owns the entity would have coverage for owning it, but if they own a vehicle personally and the business is insuring it on behalf of the insuring it, even though it's owned personally by the owner of the business, partner, stockholder, member, then they have no coverage. So you would need to add these endorsements because of the owners of non-owned covered autos. They're not automatically insured even if the auto is listed in the policy. The use covered, meaning any legal entity you name, and the permissive user is covered, but not the legal entity, partnerships, LLCs, and corporations. So we have these four endorsements. C 9947, employee as lessor. This is the owners of the U. I wouldn't do this with any quote employee, but this is for the partnership, partners owning the vehicles personally. This is for the stockholders or the members of stockholders of a corporation, members of a LLC. They own the vehicle personally. They have the business to insure it. Why they own it personally could be for financial reasons, meaning that they could not meet the requirements for financing purposes or leasing purposes, and or they were a proprietor and now they're incorporated and they don't change the title. You schedule the vehicle on the policy, the legal entity, corporation, partnership, LLC is covered, but not the owner, who in this case owns it too. You use the CA 9947, employee as lessor. There does not have to be a written lease. The enforcement of a lease, whether it's written or verbally, is the same. The only difference in a written lease and a verbal lease is, does the parties remember what they agreed to? I promise you, your insured will not forget they agreed to indemnify themselves when their own corporation uses a vehicle they own personally. So it doesn't have to be a written lease. This then makes that non-owned auto, by definition, to be a covered auto. It makes the coverage primary. It makes it ability to list it in item 3 of the deck, and it now makes that owner of the vehicle, which is also the owner of the business, and insured for their ownership of the business. CA 201, additional insured lessor. This is for long-term finance leases. These are for the riders. These are for the packed cars. This is for GMAC leasing. This is required in all leasing agreements to add this person. The CA to these entities as a fulfilling a lease. The only time you want to use this is when there is a written lease and the lessor, the leasing company, requires your insurance, the lessee, to make them additional insured. This also has a loss payee provision in it, and it also requires notice of cancellation if that vehicle is removed from the policy or canceled mid-term. Not expiration, not renewal, but mid-term. The key component here is, again, it makes the vehicle considered an owned auto. It covers the owner of the vehicle for the liability for owning that vehicle. And in the case of CA 201, it also has a cancellation provision. Hired car specified as owned autos, that's CA 9916. This is where the vehicle we want to add, mainly the trucking business, where you have the owner-operators that are affiliating with a fleet, and we want to cover the owner-operators when the vehicle is scheduled on the policy. That's CA 9916. Again, it makes the vehicle an owned auto. By definition, making coverage primary and covers the owner of that vehicle. In this case, as long as they're still leased to and the vehicle is being used by your insured. So those 3 endorsements cover the owners of non-owned covered autos that we have under the policy. It covers the owner of the vehicle. If it's an individual who also owns the business, it covers the leasing company for some consideration. It covers the owner-operators. That coverage is on primary. There is one other endorsement. That's employee as insured. This is if you have non-auto coverage. This is CA 9933. This is employee as insured. This is when the employee is using their own vehicle and you have non-owned auto coverage in the form. What happens here is a loss happens. This is where your employees as sales rep are going down on errands on your on behalf of your insured. A lot of times the mechanics your insured hires drives their own pickup truck and does their own service work. If an accident happens, the insured will be named in the suit because the employee is on the mission of the insured. This is a servant master rule. The insured will be sued, and so will the employee. The CA 9938 endorsement works this way. The employee's coverage would be primary on their owned autos. The employee's policy would also protect the business as long as there's enough limits. The CA 9933 endorsement would pay in excess of the employee's coverage. And so that's a very useful endorsement. There's not much additional exposure here. Strongly recommend if you have insureds who have employees using employees' personally owned vehicles on behalf of the insured. Sales reps, again, a lot of clerical work where you pick up and delivery, mechanics, those kind of things in those areas. The underwriting consideration here is to make sure that the employee has a high enough limit of coverage. This is the employee as lessor. This additional insured CA 201, additional insured loss payee. There is a provision in this that becomes important here. And this is to satisfy the insured's obligation in this part of it. And the key part here is we're going to make, for at least autos described in the schedule, the who's insured provision is changed to include as an insured the named owner. However, that's the key wording. However, the insured, the lessor is insured only for the bodily injury property when arising out of the acts of omission by our insureds or one of their permissive user or any person other than the employee of the leasing company for their vicarious action. So this does not make them liable for their negligence. The big difference here is when your insured leases the vehicle, if the leasing company has to maintain the vehicle and the accident is caused by the poor maintenance of the leasing company, they're not covered by this endorsement. They're only covered when they're being held vicariously liable for the insured. And a part of this is, some of you who are technically involved in this, we're actually making this leasing company an insurer for something they cannot be held liable for, and that is the Graves Amendment, which is a federal amendment that says a leasing company cannot be held liable for the actions of the lessee. And what this says is the leasing company only is covered under the policy when they're held liable for the actions of the lessee. So that's a consideration in this endorsement. The hired car specifies on all autos. Again, the big part here is while any covered auto described in the schedule is rented or leased to you and is being used by you. And so those are the concerns that we have in those. This is employee as insured. This covers it then as excess because it's not still a non-owned auto. It does not cover it to a owned auto. It's still a non-owned auto. That's that endorsement. So who is an insured? You, anyone named on the deck sheet, anyone permissive user, employee or not, family member or not, but not the owners of non-owned covered autos. You have to add endorsements to cover the owners. CA 9947, 2001, 9916 makes the owner a primary covered under the policy and gives them protection. CA 9933 is for employees, and that will be in excess of the employee's policy. Anyone held liable for the insured above is also covered, and you can add the designated insured endorsement, but it provides no additional coverage for them. That is the second hour of the 4-hour business auto lecture. I hope that you find this beneficial. It'll be posted on our website. If there are any questions, please let us know. We look forward to you participating in the third hour, which will be in March. We'll send you an invitation here to complete the 4-hour CE. Thank you very much for your time and attention. We hope you got something out of this. Have a good day.